Hello, welcome to this webinar on renunciation of U.S. citizenship. I'm Nita Upadhye. I'm the founder and managing attorney of NNU Immigration. We're dedicated exclusively to U.S. immigration work, and we're based in London, United Kingdom. Today I'm going to talk to you about renunciation of U.S. citizenship. It is a process that is a formal process that is undertaken at a U.S. embassy abroad. It can't be done in the U.S., so we'll cover that in a moment. And it is a permanent process. It is irrevocable and irreversible. So it's a decision that is made, should be made extremely carefully. And it should be made with the guidance of a lawyer, so that if you are looking to go through renunciation of U.S. citizenship, you're doing so with due consideration of all of the ramifications of loss of nationality. You understand and you're fully aware of your rights and your responsibilities and the obligations that you have, and the rights that you're giving up when you give up citizenship. So we're going to talk about some of the key considerations. We're also going to talk about the frequently asked questions raised by those thinking of severing ties with Pakistan. One of the things to consider will be, the question that often comes up is, how can I still travel to the United States if I give up my citizenship? Well, first of all, you want to think about why you're giving up citizenship. And for a lot of people, it has to do with simplifying their life. They've got another nationality, maybe they've raised a family in another country, they've been working in another country, they have property holdings in another country, and they just decide that they no longer want to have to file tax returns and FBARs and have to deal with all of these restrictions that U.S. citizens abroad might have to deal with from the compliance standpoint. But oftentimes they say, look, I don't want to have to be in the U.S. tax net anymore, but I still want to be able to travel to the U.S. So am I going to be able to travel to the U.S. in the future? And the answer is probably. Renunciation doesn't result in a permanent bar from entry to the United States. One who gives up U.S. citizenship under the current law can still travel to the United States as a visitor, or possibly as an employee of a company wanting to transfer them. Generally speaking, someone can travel to the U.S. However, you'd have to determine whether you are admissible to the United States, or if there's any reason why you wouldn't be able to travel. And that means we have to look at, when we have a client come to us and say, I'm giving up my citizenship, I've given this a long, hard consideration, but I still want to travel, can I still do that? One of the first questions we ask is, have you ever had any police interaction? Have you ever had any encounters with the police? Have you ever been cautioned, arrested, convicted? Parking tickets aside, have you ever had any sort of arrest or criminal record? If that's the case, then we'd have to look very carefully if that person could enter as a visitor. They are not likely to be able to enter through ESTA under the visa waiver program. So we'd have to look very carefully at is there a reason why they would be barred from entry. So if you've got a criminal conviction, then you'd want to see a lawyer about whether giving up U.S. citizenship is the right move for you. Because if you do give it up and you try to travel to the U.S., then there could be problems for you. So for someone who has a clean record and just wants to travel for business or a holiday, then ESTA could be available to you. ESTA is the electronic system for travel authorization. It's a system set up by the U.S. Department of Homeland Security. For those who want to travel as visitors, they have to first enroll through ESTA and get an approval through this ESTA website before they can travel to the U.S. Typically, you're granted a 2-year duration on the ESTA authorization. So the short of it is that if you do have a clean record and no reason for an inadmissibility, you can travel even after you give up your citizenship. The next question that often comes up is, can I still work in the U.S. in the future if I give up citizenship. And what we tell our clients is that you can work provided you apply for the appropriate visa. So you need to obtain a work visa, and that can take some time, but you could still be eligible for that. You just have to understand that it is a process, and it could take several weeks, if not several months, to get the correct visa in place for you to be able to work. But we do often have clients come to us and say, look, I might have to go for an assignment in the US. I'm starting a new job. That company has an office in the US, and I want to make sure that I'm still able to travel and work in the US if that arose. And we say a lot of it depends on the type of role you'd be taking in the US, your experience, and the type of visa that could be available to you. But you potentially could work in the US even after you give up your US citizenship. Now, when you apply for a visa, you're going to have to undergo a certain amount of scrutiny that you wouldn't otherwise have to go through if you maintained your US citizenship. So by renouncing citizenship, you permanently give up your right to travel freely and work freely in the United States. So again, it's something that you need to consider very carefully if you believe that you're going to have to travel frequently or perhaps work on a long-term basis in the US. Now, another question that often comes up is, how is this going to impact my family? How is it going to impact my spouse or my children and their ability to live, work, or study in the United States? The answer is it depends a lot on whether a child already has a US passport or whether they perhaps have a green card and what their current position is. Now, if you are a US citizen and let's suppose that you have just had a child, you may be eligible to transmit citizenship to that child, and that child would then have citizenship until they decide to give up their citizenship, which is about at age 18 is when they can form, when the law sees that they've formed, are able to form the intent to give up citizenship. So you as a parent, if you decide to give up citizenship and your child already has citizenship, your relinquishment of citizenship doesn't necessarily impact that child, will not impact that child's citizenship because that child, when the child becomes the age of maturity, becomes an adult, will then have to make an independent decision. A parent cannot renounce on behalf of a child. If a spouse has US citizenship, equally, you would not be able to renounce on behalf of your spouse. Your spouse would have to independently choose to renounce citizenship. So by you giving up citizenship, it doesn't necessarily impact your spouse or children if they do have US citizenship. Now, if they do not yet have citizenship and you're choosing to give up your citizenship, then you will sever your ability, permanently bar you from sponsoring them for citizenship or sponsoring them for a green card to be able to allow them to live, work, or study in the United States. Some of this has to do on their current status as to whether they will have the ability to live, work, or study in the United States in the future. So if your spouse or children do want to have citizenship, or you believe that it would be in their best interest to have those opportunities in the US and have citizenship to be able to pursue those opportunities, you may wish to look at whether it's possible to transmit citizenship to your children if you haven't done so, or sponsor your children or spouse for green cards before you then choose to give up citizenship to allow them those opportunities in the future. Yes, I mean, in terms of the next slide talks about, foreign spouse, but the foreign spouse might have be on a career path that could lead to an assignment in the United States. And if you, as a husband or wife of the foreign spouse, decides to give up citizenship, it could eliminate their opportunities in the U.S. So narrow the scope of options for family members. And that's why it's quite important to have a very thorough discussion about everything that you would give up if you give up your citizenship, how that would affect your family members as well. Now let's talk about the nuts and bolts of renunciation. What procedurally, if you've come to that decision, if you've given this due consideration, if you know that this is voluntarily a decision that you're making without any sort of undue coercion, without anyone influencing you in any way, if you've come to the decision that yes, this is the right move for me and this point of time in my life, I've considered how it's going to impact myself, I've considered how it's going to impact my family, and I've decided it is the best move for me. If you've come to that decision after you've considered it long and hard and carefully, talked to your lawyer about it, then the next thing to do is to actually go through the procedures to give up citizenship. Procedurally, it involves the submission, a careful submission of certain application documents, certain civil documents, supporting documents to a U.S. embassy abroad. The process cannot be dealt with inside of the U.S. It must be done outside of the U.S. at an embassy abroad. And an in-person meeting, you have to have a meeting in person with a consular officer. You also have to give an oath of renunciation. And I've just on this slide provided the actual oath of renunciation that you would say in front of a consular officer if you were to decide to give up your citizenship. And you would have to say to a consular officer, I desire and hereby make a formal renunciation of my U.S. nationalities provided by Section 34985 of the Immigration and Nationality Act of 1952 as amended and pursuant thereto. I hereby absolutely and entirely renounce my United States nationality, together with all rights and privileges and all duties and allegiance and fidelity thereunto pertaining. I make this renunciation intentionally, voluntarily, and of my own free will, free of any duress or undue influence. So that is the oath of renunciation. Once you make that statement in front of a consular officer, you have then formally renounced U.S. citizenship. Now, following the oath of renunciation, you will have to pay a fee of, at the moment it is $2,350 US to the U.S. government. You pay that on the day of your embassy visit. Following that, you'll want to make sure that you arrange for courier delivery service for the certificate of loss of nationality, which will come from through Washington a few months from the time of your appointment. So those are sort of the logistics of formally renouncing citizenship. It involves a submission of documentation followed by an invitation for an in-person interview in which you would take the oath of renunciation, you would pay a fee, you would then pay a courier fee for the return of your certificate of loss of nationality. Now on that appointment, on that day, you're going to be giving up your U.S. passport, physically giving up your U.S. passport. So the question often arises is, what if I need to travel before I get my certificate of loss of nationality? Now, getting that certificate can take, anywhere from 8 to 12 weeks from the time of your appointment. So during that period, you're without a U.S. passport, but you haven't received a formal certificate of loss of nationality. So logically, one would think, well, I've surrendered my U.S. passport, I have my UK passport, so I must have to travel with that as a UK visitor. And our position is that is indeed the way that you would need to travel. The U.S. Embassy's position is you may need to get a temporary visa, a temporary U.S. passport to travel during that period. We've never actually seen that take place. We've never seen someone apply for that temporary visa, so we don't know how that actually looks. But it is a bit of a gray area as to during that period, are you a U.S. citizen or are you not? Now, once you get your certificate of loss of nationality, that certificate is retroactive. So the certificate will show that you have indeed renounced citizenship as of the date that you have formally given the oath. So from a legal position, from a legal standpoint, you would have renounced citizenship on the day that you given the oath, even though your certificate comes, the formality of receiving that certificate comes a few months thereafter. Now, it's also just useful to note that the names of those renouncing citizenship are published in the Federal Register, which is the official government record reporting the number of people giving up citizenship. So there is a formal record of your renunciation of U.S. citizenship. Now, I just have a slide here on what does the certificate of loss of nationality actually look like. This is an actual redacted document from the Department of State in Washington, and this is the official certificate of loss of nationality that's been endorsed with the seal of the government. What you might be able to see here is that the effective date, so moving down sort of into the middle of the form, you'll see that there is a date at which the applicant has appeared for their interview, and that is the effective date of the renunciation, even though the date up in the upper right-hand corner shows the date a few weeks thereafter. That's the date that the certificate of loss of nationality was stamped, but the wording is such that the effective date of renunciation is the date of appearance in front of a consular officer in which you would have given an oath of renunciation. Now, a few other questions often come up about renunciation, and one question I often come across is, can I give up my citizenship from the United States? The short answer is no. Under the Immigration and Nationality Act, Section 349A5, this is the section of law governing the right of a U.S. citizen to renounce U.S. citizenship abroad. Three requirements are that the individual U.S. citizen appear in person before a U.S. consular officer, diplomatic officer, in a foreign country at a U.S. embassy or consulate, and signs an oath of renunciation. So renunciations abroad that don't meet that condition don't have legal effect. Renunciation also cannot be done through the post or electronically or through other agents. It's extremely important that it be done voluntarily, again, under no coercion or duress, and that it be completely at your own free will. Now, another question that comes up is, can my child born in the UK acquire U.S. citizenship after I give mine up? The short answer of that is probably not, unless your spouse is a U.S. citizen and unless your U.S. citizen spouse meets certain key requirements. So I've just gone through briefly in what circumstances citizenship can be transmitted even after you give up citizenship. So generally speaking, a child born outside of the U.S. to one or two U.S. citizen parents may be eligible for transmission of U.S. citizenship, but the parent or parents must be U.S. citizens at the time of child's birth. So if you've got a situation where two parents were U.S. citizens and both gave up citizenship and then had a child abroad, there is no means for transmitting U.S. citizenship to that child, regardless of how many years the parents held U.S. citizenship. The same would apply for one U.S. citizen parent, whether it's a father or a mother, would not be able to transmit after they relinquish citizenship. But just for your interest in terms of transmission of citizenship, generally speaking, birth abroad to U.S. citizen parents, if they're married, would allow for transmission of citizenship in the case of a child born after 1952, as long as one parent resided in the U.S. at any time. If a child is born out of wedlock to a U.S. citizen mother, and again, that U.S. citizen mother would have to be a U.S. citizen at the time of the child's birth. Again, taking the example of a child born after 1952, the mother would have to be physically present in the U.S. continuously for 12 months prior to the child's birth. Now, there is a Supreme Court decision that's just come out that is effective for children born after 2017. We'll get to that in a moment. If you're looking at the birth abroad to a U.S. citizen parent and a foreign parent, so that would be a married couple where one parent is a U.S. citizen, the other is not. Taking the example of a child born after 1986, a citizen parent must be physically present in the U.S. For 5 years prior to the child's birth to after age 14. So there's a physical presence requirement there. But again, none of this would apply if that U.S. citizen parent gives up citizenship. The child would not be eligible for transmission. Now, for a child born out of wedlock to a U.S. citizen father and a foreign mother, generally after 86, if a child was born after 86, the father must be physically present in the U.S. 5 years prior to the child's birth, to after age 14 is the general rule there. Now, it's just worth noting that there was a Supreme Court decision, Sessions v. Morales-Santana, it's recently come out, which now requires that the U.S. citizen mother and alien father have the same retention requirements, the same physical presence requirements in the U.S. So, whereas if a U.S. citizen father gives birth, if a citizen father and a foreign mother give birth to a child outside of the U.S., the father, as we know, has to be physically present in the U.S. for 5 years to after age 14. And now the mother must also, if it's a U.S. citizen mother, they must also meet the 5-year test to after age 14, whereas previously they only had to meet a 1-year test. So that's new direction under Supreme Court ruling Sessions v. Morales. That would be for children born out of wedlock on or after June 12th, 2017. So we've just done a whistle-stop tour of renunciation, and we've just had sort of 30 minutes to run you through some key considerations. There are a number of considerations to make. These are the key ones about whether you want to continue traveling to the U.S., whether you want to continue working, how is it going to impact your family. Of course, tax considerations are a big factor in the decision-making process, and you do want to talk to a tax advisor and really retain a good tax lawyer and a tax accountant to look at your tax affairs and make sure that you're fully up to date. Because there is an intersection between tax law and immigration law when it comes to renunciation. You could go through the entire renunciation process and go through the oath of renunciation, but if you don't tie up your tax affairs, then you will not have completed the renunciation process. Likewise, you could file all the tax returns that you believe are required of you and get up to date with overdue filings. But if you don't then formally renounce citizenship and take an oath of renunciation with the U.S. government, then you will not have completed the process. It's quite a solemn occasion when you give up citizenship. It is, again, an irrevocable, irreversible decision. You can't turn around the next day and decide you've made a mistake. So you want to consider it long and hard. Now, one could be eligible for citizenship at a later stage, but they wouldn't be able to regain the citizenship that they have just given up. You could go through the green card process, through marriage, or perhaps through employment, which could lead to citizenship in the future. Possibly if you have a U.S. citizen child, by the time the child turns 21, child could sponsor a parent for a green card. So there could be other paths leading back to citizenship. It's quite rare for someone to want to give up citizenship and then go back and try to reapply and go through that lengthy process to get citizenship back again. But it is an option that could be available to some. So you have to. It's a decision that should be made with the help of advisors. That should be done, and the help of your family members. Because it's a big decision, and you should have full knowledge and awareness of the consequences before taking this path of renunciation of U.S. citizenship. We hope that this overview has been helpful to you. We'd be extremely happy to help you in any way we can, specifically in taking you through the renunciation of U.S. citizenship process. We can help you through all of the legal paperwork. We can help prepare you for that all-important meeting at the embassy, ensure that you get your certificate of loss of nationality, and really talk through all of the implications and the ramifications, and so that you're well supported through this process if it is something that you choose to do. Thank you for being with us on this webinar, and we do hope to hear from you again if you have any questions. Thank you. Bye-bye.